Hello, everyone. Welcome to the legal world of Unacademy. So, you have been summoned today. What do you understand by this? What exactly is the concept of summons? In this video, we are going to learn all about summons in civil as well as criminal matters. So, first of all, let me introduce myself. My name is Tanvi Singh. I'm your Unacademy CLAT educator. I have pursued my law from Symbiosis Law School, Pune. I've earlier worked with various organizations and have been mentoring aspirants for law since past 5 years. Also, if you are interested in attending my Unacademy classes, you can simply refer to the link in the description box. You can also join my Telegram channel and even use my referral code TANVIS10 to avail additional 10% off on your Unacademy subscriptions. So let's start our session. What exactly is a summon? A summon is an order which is officially issued by a court on an individual या फिर किसी entity पे हो सकता है who may be involved in a legal proceeding. So a summon is usually served when legal action is taken against an individual. So basically a person files a case in the court. The defendant, you have to make them aware that there is a particular case that has been filed against him. So a summon is issued by the court to the defendant to make them appear for the hearing on that case. Wherein a person is required to appear before a court as a witness in a proceeding. So this document ensures that the person is called upon and his presence on the given date of hearing. जो भी date of hearing है उसमें वो person appear करे. So a summons का concept कैसे आया? There was this Latin maxim, audi alterum partem, which means that hear both sides. So it was a natural justice principle, and iske basis pe the concept of summon came into force. That once a case has been filed, then you have to hear both sides of the parties, and the defendant has to be made aware of the particular case that has been filed against him. So court जो है आपको एक summon issue करती है, and there are particulars of the date of hearing, time, and where you have to appear before the court. That is through summons only. So only through such summons, defendants become aware of proceedings against them. In the later stages of a suit, the parties can prove their case with the help of witnesses. In fact, जब आपको witnesses बुलाना होता है court में for examination, cross examination to prove a certain point, then also a summon is issued through the court. So to bring such witnesses to the court, the parties seek the court's support. Thus, summons are sent to the witnesses through the procedure laid down under Order 16 of Civil Procedure Code. Without summons, the parties cannot enforce the presence of witnesses and establish the case. Benefit of such process, the attendance of witnesses cannot be achieved thereby. The dispute cannot be resolved on merits. So let's start with the criminal matters. What exactly you understand by summons here? So summon is the same. It's a document which is issued either for the appearance or for producing a document or an item as evidence, which may be issued to an accused person or witness. So Section 61 of the Criminal Procedure Code states that every summons issued by court shall be in writing, in duplicate, along with the signature of presiding officer of such court or by such an officer as is authorized by High Court, and very important, it shall bear the seal of the High Court. The summons should be specific and clear in its term with respect to the information such as the आपकी title क्या है case का, the place at which, the date and time of the day when the attendance of that particular person summoned are required in the court. Also, Section 62 and Section 65 of the Criminal Procedure Code talks about the service of summons, the mode, how it has to be served. So the summons shall be served by a police officer or an officer of the court or any other public servant. In case the service cannot be brought into effect by exercise of due diligence, the serving officer can perform a substituted service by affixing one of the duplicates of the summons to some conspicuous part of the residence. So you have to ensure that it has been served to the summoned person. So you can, the police officer has the responsibility to either the documents duplicate has to be kept in the residence of the summoned individual, and thereupon the court, after making such inquiries, as it seems fit, may either declare that the summons have been duly served or issue a fresh service as it considers proper as stated in Section 65 of the Criminal Procedure Code. Next, Section 63 to Section 66 of Criminal Procedure Code deals with summons on corporate bodies and societies. So the service of a summon on a corporation may in effect by serving it on specific individuals who are a part of the corporation. This includes the secretary, the local manager, or any other principal officer of the corporation. A summon may be in the form of a letter sent by registered post addressed to the respective chief officer of the corporation in the country. In this case, the service of a summon shall be deemed to be in effect when the letter arrives in the ordinary course of the postal service. Generally, the meaning of word corporate in Criminal Procedure Code. Generally, the meaning of word corporate in this section of the Criminal Procedure Code means an incorporated company or any other corporate body. Also, it includes a society that is registered under the Societies Registration Act of 1860. Therefore, societies may not be a body which has been incorporated, but under Section 63 of the Criminal Procedure Code, it is mentioned that societies fall within the scope of this law. So let's come to the mode of summons. When a postal service is used to deliver summons to the corporate, it may fail to effect the service of summons as stated in Section 62. However, Section 64 provides that the extended service can be ensured by leaving a copy or duplicate of the summon with an adult male member of the person's family who resides in the same residence. It should be ensured that the receiver is asked to sign the receipt for receiving the summon. Section 64 mentions that non-family members such as a servant are not to accept a summon. When a government servant is to be summoned, the duplicate copy of the order or summon shall be sent to the head of department in the office of the employee by the court. According to Section 62 of the Criminal Procedure Code, the head is required to serve the summons in the manner provided in the section and ensure to return the same to the court with his signature with the endorsement. The signature of the head shall be used as evidence of due service as stated in Section 66 of Criminal Procedure Code. Now, Section 91 of Criminal Procedure Code talks about the summons to produce, and Section 92 as well. So, in some cases, a court or an officer of the law considers that the production of a document or any other item is essential for a proceeding, such as an investigation, inquiry, or a trial. So, under this section, a court or an officer of the court may issue a summons in a written manner to an individual who the document or item is believed to be in possession, basically to produce the evidence. This compels the particular individual to attend and produce the object at the time and place stated in the order. And if you are not complying with the order of summons, what happens? So in case any person does not comply with the summon issued by the police officer, he is liable to be prosecuted under Section 174 of IPC, Indian Penal Code, which provides punishment with simple imprisonment for a term which may extend to 1 month or with a fine which may extend to 500 rupees or maybe with both. Now let's come to the civil cases. So according to Civil Procedure Code, certain people cannot be summoned to appear in person. So it should be made sure that a summon is not served on such people. Summons is a written notice served on a person under the authority of the court to appear personally before the court. Summons in Civil Procedure Code 1908 are served on the defendants and the witnesses. Defendants are summoned to intimate that the suit has been filed against them, whereas the witnesses are summoned to demand evidence or to produce documents or both. According to Rule 19 of Order 16, the court cannot serve summons to persons who are residing outside the original jurisdiction of the court. The rule is exempted if such a person's residence is situated less than 50 miles from the courthouse, and even in the case where the person's residence is situated less than 200 miles from the courthouse, where there is an availability of public transport. Apart from this, women, according to certain customs, who do not appear in public cannot be summoned to appear in person before a court, nor arrested under Section 132 of Civil Procedure Code 1908. Section 133 exempts persons holding constitutional positions from personal appearance in the court. So they cannot be summoned by the court either. List of witnesses. Under civil cases, Order 16, Rule 1 of Civil Procedure Code stipulates that a list of witnesses has to be submitted to the court by the parties. Such a list consisting of witnesses has to state details such as whether the witnesses are summoned for giving evidence or to produce documents or both. This list has to be submitted within 15 days from the date on which the issues are framed. But the entire summons process itself is not mandatory under Civil Procedure Code. A witness can also be produced before the court without the name in the witness list or even without a summons under Rule 1A of Order 16. This is used in cases where the parties does not require the court's help in bringing a witness to the court. So only when the party is unable to bring the witness by himself, the court's help is sought and a summon is sent. Under Rule 14 of Order 16, the court may also summon a witness suo motu if the court feels that it is necessary to serve justice. The court can examine such witnesses on its discretion and may require such a person to produce any evidence or documents that he can. Now, essentials in a summon. So, as per Order 5, Rule 1, the basic necessity in any summons is the sign of the judge and seal of the court issuing the summons. With respect to the summons to a witness if it is being sent, Rule 5 of Order 16 under the CPC states that particulars such as date and time at which the witness is required to attend are to be specified. Along with these, the reason for the procurement of the attendance of witness, why they are being summoned, such as to give evidence or to produce a document, or both should also be mentioned in the summons. If the witness is called for producing any document, the name and description of the document required should also be mentioned in the summons. Mode of service of summons. Summons to a witness can be served in different ways as it is served to the defendant under Order 5. Summons can be delivered personally to the person or his authorized agent. If the person cannot be found in his residence for a reasonable time, the summons can be delivered to any adult family member residing with the witness. The court can serve the summons through its court officer or by registered post, acknowledgement due. This shall be the most preferred method as there is a proof of acknowledgement slip and there can be no false report of service of summons. If the person consciously avoids the summons and cannot be reached by any means, the court officer can affix the summons on the door or the other conspicuous part of the house where the person resides or on the place where the person carries business. The Supreme Court recently, in a suo motu writ petition for the extension of limitation period due to lockdown, held that digital mediums such as WhatsApp, Telegram, and email can also be used to send summons. It was also held that the blue tick in WhatsApp can be considered as the acknowledgement of the service. Now, summons outside the court's jurisdiction. A court cannot summon a person residing outside its jurisdiction. In that case, Order 5, Rule 21 provides that the court may issue the summons to a court having jurisdiction over the person's residence to its officer or by other means such as post or electronic mail service. Then Rule 23 enables such a court to which the summons is sent to serve the summons. Now, according to Section 31 of Civil Procedure Code, Section 27, 28, and 29 can also apply in the case of summons to witnesses. Section 28 states that in service of summons outside the state, the summons has to be sent to a court with jurisdiction in the other state and it has to be in accordance with the rules in the transferee state. Such a court can serve the summon and a translation can also be made accordingly. Similarly, Section 29, a foreign summons passed by a court in India which does not come under Civil Procedure Code or a court under the authority of Central Government of India outside India or a court notified by government in official gazette under the section can be sent to courts under the CPC for service of such summons. Now, if you do not comply with summons under civil matters, in the case the witness fails to comply with the summons served, the person will face consequences laid down under Rule 10 of Order 60. In such a situation, it is given that the court may issue a proclamation stating that the person to be present at the specific time and date for giving evidence or to produce the document or a copy of the proclamation has to be affixed on the witness's outer door or any conspicuous part of the house. Along with this, the court or on its discretion may also issue a warrant to arrest the person for not appearing. Rule 12 states that the court could impose a fine less than 500 rupees for non-appearance, pertaining to which the court could also attach the property of the person in order to recover the fine if imposed. All this consequence would be avoided if the person gives any lawful excuse to the court for his absence. Now let's conclude our session. Once the issues are framed in a civil dispute, the parties initially have to classify the witnesses, whom they can bring by themselves and whom they cannot bring. Accordingly, एक आपका list of witnesses consisting of the witnesses who can be produced only with court's assistance has to be made and submitted to the court. Thus, the summons are issued and they should be served on the witnesses in modes prescribed by the statutes. Under civil matters, it's Civil Procedure Code, by which those witnesses become legally responsible to attend the proceedings. Such witnesses will be penalized if they don't obey the summons and appear before them. Whereas in criminal matters, criminal sanctions for failure to obey the summons illustrates the significance of summons to witnesses. In a dispute, the witnesses usually have no interest in the case. They have nothing to lose if they don't carry out the responsibility of a witness. But a summon from court creates a liability on the person to whom it is issued, by which the person has to attend unless they come under the given exceptions. The reason behind such a coercive process is to obtain a just decision in the end, which can be done based only on the evidence and the documents acquired from the witness. So that's it for today. Thank you so much. I hope you enjoyed this video. Thank you.